Hello and welcome everyone. My name is Amanda Stedman. I'm the Principal Knowledge Lawyer here at BDBF, and I'm joined today by my colleague Esmat Fays, an associate in our team. Today we are talking about the Employment Rights Bill, the government's flagship piece of employment legislation which will introduce wide-ranging employment law changes. Although compliance with the bill is somewhat daunting, they say that forewarned is forearmed, so today we hope to bring you up to speed on what's in the bill and, importantly, what has changed over the course of this year. The bill has almost completed its passage through Parliament and is expected to pass into law in early November, becoming the Employment Rights Act 2025. However, you'll be relieved to hear that not all of the changes will come into force straight away. Some will be deferred to 2026 or 2027, and some are contingent on secondary legislation, which itself will be subject to further consultation. In July, the government published a roadmap setting out their proposed timetable for further consultation and implementation of the reforms, and we will flag those dates as we go through each area today. In order to make our webinar as meaningful as possible, we have decided to focus on what we think are the most important aspects of the bill for the employers attending this webinar, primarily those areas affecting individual employment rights. And that does mean that we will not be looking at certain sector-specific measures in the bill, measures concerning trade unions and industrial action, nor the state enforcement body, the Fair Work Agency. We will speak for about an hour today, and after that there will be some time for Q&A. We're presenting in webinar format, so that means the best way for you to ask questions is using the Q&A box at the bottom of your screen, and you can do that anonymously if you prefer. And finally, today's session is being recorded. The Q&A part won't be. And after the session, we will circulate a copy of the recording together with the slides that we are using today. So turning first then to perhaps the most significant provision in the bill, the proposal to give employees a day one right to claim unfair dismissal. Currently, employees need 2 years service with their employer before they can bring a claim of ordinary unfair dismissal. There is a limited exception to this if it can be shown that the dismissal was for one of a number of inadmissible reasons, such as for having blown the whistle. And in such cases, employees may claim automatic unfair dismissal from day one of their employment. Alternatively, if it could be shown that the dismissal was discriminatory, the employee may bring a discrimination claim in relation to the dismissal, again from the first day of employment. But absent these aggravating factors, employers are able to dismiss employees with under 2 years service relatively easily. There's no need to identify a fair reason for the dismissal, and nor do you need to show that you've acted reasonably, including by following any particular process. The bill will remove the 2-year qualifying period for ordinary unfair dismissal claims, converting them to a day one employment right for all employees. Now, this has proven to be a controversial part of the bill, which raised criticism when it was debated in the House of Lords in July. In particular, concerns were raised about the disproportionate effect on small businesses without an HR function and the freezing effect that it may have on recruitment. And that was a concern echoed by the Federation of Small Businesses. In fact, the Lords went as far as to amend the bill to introduce a qualifying period of 6 months, so still lower than the 2 years we currently have, but still a qualifying period nonetheless. However, this amendment was rejected by the Commons in September. So it remains a day one right as it stands, but there is an important caveat to this. New rules will make it easier to achieve a fair dismissal during a new statutory probationary period, which will be known as the Initial Period of Employment, or the IPE. During the IPE, the usual standard of reasonableness that has to be met to dismiss fairly will be modified. In other words, a bit less will be expected from you when dismissing a relatively new employee. So that is helpful, but regulations are needed to answer some important known unknowns about this proposed light touch procedure. Firstly, exactly how the reasonableness test will be modified remains to be seen. It has been suggested that all that will be required is that you will have to meet with the employee before the proposed dismissal. If that is all that's required, then most of you will breathe a sigh of relief, because a single meeting before a dismissal is not going to be that onerous and may well be something that you do already, but we will have to wait and see. The second known unknown is the length of this initial period of employment. The government has previously signalled its preference for this to be set at 9 months, and in practice that would be longer than most contractual probationary periods, which generally sit at around 3 months. But subject to that detail, making it simpler to dismiss new employees clearly takes some of the sting out of this reform for employers. That said, you do need to take care, because there are some traps for the unwary. The first trap is that the bill provides that this light touch procedure will only apply to dismissals where either the dismissal takes effect before the end of the IPE, or you give notice before the end of the IPE and the dismissal takes effect within 3 months of the end of the IPE. So, for example, if you gave notice at the end of the IPE, but the employee had a 6-month notice period, you would find yourself falling outside the light touch approach. And it's not yet clear what the effect of paying in lieu of notice would be in such circumstances. The second trap to note is that the bill also provides that this light touch approach will not apply at all to certain types of dismissals, and these are redundancy dismissals and dismissals for some other substantial reason which do not relate to the employee. So, for example, the expiry of a fixed-term contract. For these type of dismissals, the usual reasonableness test will apply. No shortcut will be available. So, for example, if you decide to make an employee redundant after, say, 3 months of employment, you will be required to undertake the process in the same way that you would for an employee who'd been with you for 3 years or 30 years. So what will all of this mean for you as employers? Well, the abolition of the qualifying period is certain to generate more grievances and more tribunal claims. So what things can you do to minimise the risk? Well, I think firstly, you can be more cautious when it comes to recruitment, so as to limit the risk of a bad hire in the first place, conducting appropriate due diligence, taking up references, thinking about other ways to test employees, such as competency tests. The second tip is to make sure that when you onboard a new employee, take care to diarise the relevant dates and ensure that any notice to terminate is given by the end of the IPE at the latest. And once someone is on board, make sure that line managers are proactively managing the employee during the initial period of employment. And that's to make sure that any performance or conduct issues are addressed at an early stage and not allowed to drift, because if they do, then you will lose the opportunity to take advantage of the light touch process. You'll also need to give some consideration to the interplay between your own contractual probationary period and the statutory initial period of employment. You do not necessarily need to increase your contractual probationary period to align with the initial period of employment. On the face of it, there's nothing to prevent you from dismissing an employee who has already passed their contractual probationary period during what's left of the IPE. That said, you may feel it's sensible to align the two periods. It's also important to remember that it's not the case that new employees will never be able to bring an unfair dismissal claim. Although this light touch process will make it easier for you to dismiss them, we know that you are still going to be required to do something. So don't be tempted to short circuit even those modified requirements, because that could open the door to an unfair dismissal claim. And as I've mentioned, remember that certain types of dismissals, redundancy, and certain SOSR dismissals, it will be the case that the ordinary test will remain. And a final point to note is that the bill provides that the government may introduce a cap on the compensatory award for employees who are dismissed during the IPE, and that suggests that a lower level of compensation will be available to those employees, although it's not yet known what that level will be. If that comes to pass, you may wish to consider buying out claims from new employees instead of fighting them, because that obviously brings the associated loss of management time and legal fees. In terms of what's next, the good news is that there is quite a bit of time to prepare for this change. The government announced in its roadmap that this right will be implemented, quotes, sometime in 2027. We don't know when. Why such a long wait? Well, the government has two key things to do. First, it says it will consult on the details of this new right this autumn. We're waiting for the consultation paper to be published any day now. And once that consultation process is complete, new regulations will be drafted and passed in Parliament, and we expect those to be published in 2026 once the consultation has been wrapped up. So do keep an eye out for both the consultation and the regulations, as these will provide much more detail about how this right is going to work. Staying on the theme of dismissals, let's consider what's proposed in the field of collective redundancies, and quite a lot has happened in this area since the initial publication of the bill. So currently, you will all know that collective redundancy consultation is triggered where there's a proposal to dismiss as redundant 20 or more employees within a 90-day period where they are assigned to one establishment, and that getting it wrong can land you with a protective award of up to 90 days gross pay. The question of what counts as an establishment has been explored in litigation in the past, most famously in the Woolworths case, where employees argued that it should mean the business as a whole rather than the local place of work. This would mean that collective consultation would be triggered more easily, as redundancy numbers to get to that all-important 20 threshold would be counted across the whole business. However, the senior courts found in favour of employers and decided that establishment doesn't mean the whole business, it in fact means the local unit. Now, the bill proposes some changes to this. Originally, it had proposed to reverse this position altogether, so that collective consultation would be triggered where 20 proposed redundancies across the 90-day period were achieved across the entire business rather than the local workplace. And to add to that pain, very shortly after the bill was published, a consultation was opened on further proposals for strengthening the remedies available for breaches of the rules. First, the consultation asked whether the maximum protective award should be increased above 90 days, either to 180 days or to remove the cap altogether. It also talked about introducing the rather onerous remedy of interim relief. And for reasons that will become clear in a moment, I'm not going to say any more about this. So these were quite some significant proposals, but things, as I said, have evolved somewhat since these early days. In March this year, the government published some amendments to the draft bill alongside its response to the consultation. And essentially, they have rowed back on some of the punchier proposals. So how do things now stand? Well, firstly, in relation to the threshold for consultation, the bill has been amended so that collective consultation will be triggered where there's a proposal to dismiss as redundant within a 90-day period, either 20 or more employees assigned to an establishment, and that means the local unit where the employee works. So that's essentially the current position that we have now. Or it could also be triggered where a threshold number of employees across the whole business is met. And that threshold number may either be a specified number of redundancies across the business, or an overall percentage of your workforce, or it may be defined in some other way. And this detail has yet to be set down by the government. The second change relates to the protective award. Following the publication of the response to the consultation, the government confirmed that it would be setting the protective award at 180 days gross pay rather than leaving the award uncapped. So it is a doubling, but it could have been worse. And finally, the remedy of interim relief will not be extended to protective award claims. So what does this all mean for you? Well, the retention of the words at one establishment, i.e. the current position, is a concession to business and should mean that collective consultation will not be triggered where a multi-site employer proposes small pockets of redundancies at different sites unless that new threshold is breached. Clearly, the level at which this new threshold is set will be important. The lower it is, the more likely that collective consultation will be required. In terms of tracking redundancies, it will be the case that multi-site employers will need to have a system in place to make sure they keep track of proposed redundancy numbers across a rolling 90-day period to monitor when they are about to exceed the new threshold, whatever that is set at. And remember here that collective redundancies have to be notified to the Secretary of State via the HR1 form, and a failure to do so is a criminal offence. So it's not just the risk of tribunal claims that we're worried about here, it's also that risk of a criminal offence having occurred. In terms of the process itself, the election process will be administratively more burdensome because you will need to make sure that you have representatives in place for all affected employees, no matter where they are based. And in terms of the consultation itself, it may become a bit more cumbersome and disjointed because you may be consulting about different pockets of unrelated redundancies at different locations. But helpfully, the amendments that were made to the bill in March provided that while employers will be required to notify representatives of the total number of redundancies across the business, they will not be required to consult all such representatives together, nor undertake consultation with a view to reaching the same agreement with all of them. That's helpful, but it does mean that ultimately more time and resources will need to be devoted to the process, as you will have to organise and manage multiple consultation meetings. And finally, with the enhanced remedy available for breaches of collective consultation rules, this could act as a deterrent to buying out these claims because effectively you'd be paying out a half-year wage bill. So that may encourage you to try to tackle difficult consultation processes. In terms of what's next, the government's roadmap provides for 3 key staging posts for these reforms. So first, later this year or possibly early next year, a consultation will be opened on seeking views on this threshold number across the wider business, and regulations will also need to be drafted. In April 2026, so just 6 months away, the protective award will be increased to 180 days. But do remember that tribunals will retain discretion to set the award at a figure which reflects the severity of the breach. So it does mean that minor breaches should not incur a 180-day protective award. And finally, the expanded threshold for triggering consultation to cover redundancies across the whole business is due to come into effect in 2027. And the government has also promised new guidance for employers on how all of these new rules are going to work. And with that, I'm going to hand over to Esmat.
Still on the theme of dismissal, let's think about dismissal and re-engagement, aka fire and rehire. Fire and rehire is a shorthand used to describe the practice of dismissing an employee and then offering to re-engage them on less favourable terms and conditions. In July 2024, the Conservative government introduced a statutory code of practice regulating the use of dismissal and re-engagement tactics, which sets out the process to be followed by employers before dismissing and offering to re-engage in any circumstances. A breach of that process does not give rise to a legal claim in itself, but it may lead to an uplift of 25% to any compensation awarded in a related claim. The Labour Party had initially talked about ending fire and rehire practices altogether, but this was slightly watered down with a promise to end the practice save in exceptional circumstances. The original version of the bill did make fire and rehire considerably riskier for employers. The bill provided that employees would, from day one of their employment, be automatically unfairly dismissed, where they were dismissed for refusing to agree a change to their terms and conditions of employment, or they were dismissed in order to re-engage them or someone else under varied terms and conditions of employment, but where the role is otherwise substantially the same. The only exception would be the financial difficulties exception, which is where the reason for the variation was to eliminate, prevent, or significantly reduce or mitigate the effect of any financial difficulties which, at the time of dismissal, were affecting or likely to affect the employer's ability to carry on its business, and there was no way the need to make the variation could reasonably have been avoided. So the initial proposals were quite bold. However, in July this year, the government amended the bill to soften the proposals. The most significant amendment was to limit the proposed automatic unfair dismissal protection only to cases where the employee is dismissed for failing to agree a restricted variation to their terms and conditions of employment, or in order to re-engage them or someone else under varied terms and conditions of employment, where one or more of the differences between the two sets of terms constitutes a restricted variation, but where the role is otherwise substantially the same. A restricted variation will cover variations relating to pay, pensions or pension schemes, working hours, the timing or duration of shifts, and a reduction in the amount of time off. It also covers other variations of a description specified in regulations, which could extend to benefits, and it covers the inclusion of a unilateral flexibility term, enabling the employer to make any other restricted variation in the future without the employee's agreement. So where an employee is dismissed for refusing to agree any other kind of variation, or in order to re-engage them or someone else on varied terms, or a restricted variation where the financial difficulties exception applies, then the dismissal won't be automatically unfair, but it may still be ordinarily unfair. In that situation, the Employment Tribunal will consider the reason for the variation, any consultation carried out about the proposed variation, including with the trade union, anything offered to the employee in return for agreeing to the variation, and any other matters specified in regulations. The employer will also need to comply with the Code of Practice on fire and rehire or risk an uplift to any compensation. A further amendment provided that the dismissal would be automatically unfair if the reason for the dismissal was to enable the employer to replace the employee on a broadly like-for-like basis with someone who is not employed, so for example, an agency worker or a self-employed contractor. This would also include engaging the former employee stripped of their employment status. In a similar way, there is an exception to this rule where the employer can show that the reason for the replacement was to address financial difficulties and the employer could not reasonably have avoided the need to replace the employee. So what is this going to mean? Imposing certain types of contract variations will become riskier. The restricted variation change clearly softens the impact of fire and rehire provisions, but you still have a higher exposure to automatic unfair dismissal claims. The terms which would constitute restricted variations are the very terms that would usually lead an employer to consider the extreme solution of fire and rehire in the first place: pay, benefits, hours, and leave entitlements. Nor can you escape the risk of automatic unfair dismissal by simply firing in these circumstances and not offering to rehire. That will still be caught. So we would recommend that to minimise risk, you consider auditing relevant terms now and bring them into line with where you want them to be before this change comes in. Even if you can't force a contractual change through, there's nothing in the proposal to stop you from hiring new employees on the revised terms and keeping existing employees on the old terms. However, this risks the creation of a two-tier workforce, which may have perhaps different working patterns or be receiving different rates of pay. And this could in turn give rise to grievances or even claims, potentially such as an equal pay claim. So the government has said it intends to commence consultation on fire and rehire related regulations and changes to the existing Code of Practice in autumn 2025. And the new regime is expected to come into force 1 year from now. In October 2026, regulations will be needed. And the proposals on dismissals don't stop there. The bill provides that regulations may be introduced which will provide enhanced protection from dismissal during pregnancy and following return from maternity, adoption leave, shared parental leave, paternity leave, bereavement leave, and neonatal leave. The government believes extra protection is justified given evidence that employees in these groups face a particular and overwhelming risk in relation to their job security. We don't yet know in what circumstances this protection will apply. However, it is worth remembering that it's already unlawful to dismiss an employee because of her pregnancy or maternity leave. This would amount to discrimination. To dismiss an employee for a reason related to pregnancy, maternity, adoption, or shared parental leave, that would be automatic unfair dismissal. And to make an employee redundant during pregnancy or following the return from maternity leave, adoption leave, or shared parental leave, where there is a suitable alternative vacancy available. On the face of it, this proposal appears to go further and suggests that even if there is a non-discriminatory and fair reason for dismissal, the dismissal could still be unlawful, subject, we assume, to some exceptions. And common sense would suggest exceptions must be made to permit dismissal for things like gross misconduct, gross negligence, or illegality, or where there is a large-scale redundancy, such as where the whole business is closing down. We'll have to wait for the further detail to be provided. So what does this mean for you? Well, at this stage, not much. It is simply a case of awaiting the publication of the regulations to fully understand the extent of this proposal. However, do be prepared to have your hands tied to a significant extent when it comes to the dismissal of pregnant employees or family leave returners. Monitoring and meeting these requirements could be quite complex, and you will need to take care not to inadvertently trip up. You'll need robust systems and processes in place. In due course, managers and HR will also need training on this change. A consultation is expected shortly, where more detail on this proposal will be provided. The government has said it is mindful to avoid the unintended consequence of creating a reluctance to hire women of childbearing age. The government's roadmap says that this change will come into effect in 2027. And I'm going to hand over to Amanda now.
Thanks, Esmat. So moving away from dismissal, let's look at some of the equality law provisions in the bill, turning first to sexual harassment. So as you'll all know, from the 26th of October 2024, all employers were required to take some reasonable steps to prevent sexual harassment of their workers, including by third parties. Where that duty was breached, an uplift of up to 25% could be applied to compensation in any relevant claim. And further, the Equality and Human Rights Commission had the power to investigate and take enforcement action against the employer. When that change was going through Parliament, the plan had been for that duty to require employers to take all reasonable steps to prevent sexual harassment of workers. But on the passage through Parliament, the important word all was dropped on the basis that it was felt compliance would be too onerous for employers. However, the bill reverses that position and provides that the word all will be reinstated into this duty, meaning that you will be required to take all reasonable steps to prevent sexual harassment, or you risk that compensation uplift and EHRC action. On top of this, the bill says that the steps that are to be regarded as reasonable may be stipulated in law for the first time. Currently, the recommended reasonable steps to prevent sexual harassment are set out in non-statutory guidance. The bill seeks to strengthen this and says that regulations may be used to specify the types of steps that should be taken. However, the government has said it will only do this if there is a clear evidence base supporting the use of certain steps. A call for evidence was launched in April to consider this question. That closed at the end of June, and we are waiting for the outcome. And separately, in the field of sexual harassment, the bill provides that disclosures about actual or likely sexual harassment will be listed as one of the types of malpractice about which a whistleblowing disclosure may be made. That doesn't mean that they will automatically be regarded as a whistleblower, because there are still a number of other hurdles that would need to be jumped in order to get there. So what will this mean for you? Well, it will be harder to discharge the duty to prevent sexual harassment once it has been enhanced in this way, because you will need to do everything that it is reasonable for you to do. A failure to take a single reasonable step will put you in breach of the duty. If the proposal to set out a list of reasonable steps and regulations is taken forward, that will be helpful in that it at least will give you some legal certainty about the kinds of steps required, rather than leaving it up to you to decipher what you need to do by reference to non-binding guidance. Although a note of caution, any such list is unlikely to be exhaustive, since the steps will ultimately vary from employer to employer, depending on, for example, things like your size or your sector, but it will be a sound starting point. Although it will be some time before these changes come into force, we think it would be wise for you to begin working towards taking all reasonable steps now. Not only will this help you be ready for the raised requirement in good time, it also has the advantage of opening up the possibility of pleading the all reasonable steps defence, which is currently available in relevant sexual harassment claims. If you want to do that, you should consult the EHRC's guidance, which sets out the types of steps expected from employers, added to which, do go back and have a look at your own sexual harassment risk assessment, which you will have put in place before the duty came into force in 2024, because that will identify the risks specific to your sector and workplace and may point to additional reasonable steps that you can take. So when is this all happening? Well, the bill will expand the duty to prevent by amending the Equality Act. No regulations are needed for that change. So it's quite straightforward. The government's roadmap says it will come into force a year from now in October 2026. However, the proposal to set out the reasonable steps in law does need regulations, and the government has indicated that will not be in place until 2027. Although, as I said, it's possible they may not materialise at all. Much will depend on the outcome of the call for evidence that I mentioned, which is due shortly. In the meantime, the EHRC's guidance on what counts as a reasonable step will apply. And finally, bringing sexual harassment disclosures within whistleblowing law will be done by amending the Employment Rights Act. No regulations are needed, and that change will come into force in 6 months' time in April 2026. Moving on then to think about third-party harassment. The Equality Act used to contain provisions making employers liable for harassment of staff by third parties, so basically anyone outside the workforce. But that liability only arose where you were aware that your worker had been harassed by the third party on at least 2 occasions. Those provisions were repealed back in 2013, with the result that it became much more difficult for workers to bring claims against their employer where they had been harassed by a third party. The bill proposes to bring back employers' liability for third-party harassment, and there are 2 really important points to note here. This will extend to harassment related to most protected characteristics in the Equality Act, not just sexual harassment. And further, liability will arise from the first instance of harassment, and the employer does not need to have been aware of that harassment. So in those respects, this proposal is more onerous than the previous iteration of the law. What will this mean for you? Well, the reinstatement of liability for third-party harassment significantly widens your exposure to claims of discriminatory harassment. Where your staff frequently interface with the general public, that risk will be heightened, but really all employers will need to be wary of this and apply their minds to situations where it could arise. So in terms of what you can do now, we think it would be sensible to devote some time to mapping out the types of scenarios where your staff are likely to come into contact with third parties and identify where you have some degree of control or leverage over that third party. So, for example, a contractor or a supplier, as against those situations where you don't, for example, the general public. Once you've done that mapping exercise, then you can start thinking about what the potential risks might be and what steps you could reasonably take to minimise those risks. And I've set out in the box on the slide some examples of the types of things that you can do, but I'm not going to talk through them. The hope is also that in time the government will issue some guidance for employers about what's expected. In terms of timing for this change, the bill will introduce third-party harassment by amending the Equality Act. No regulations are needed, and the government has indicated that it does not intend to consult on this change. It is expected to come into force a year from now in October 2026. And I'm going to hand back to Esmat.
Thanks, Amanda. So now on to a late addition to the bill and something that took us a little by surprise. In July, the government tabled a significant amendment to the bill addressing contractual duties of confidentiality relating to harassment and discrimination, commonly known as non-disclosure agreements or NDAs. In future, any provision in an agreement between an employer and worker will be void insofar as it purports to prevent the worker from making an allegation or a disclosure of information relating to either relevant harassment or discrimination, or the employer's response to either the relevant harassment or discrimination itself, or to the making of an allegation or disclosure of relevant harassment or discrimination. So let's unpack what this means. What is an allegation? Allegation's not defined in the bill, but it's defined in the dictionary as a statement that someone has done something wrong or illegal, made without proof that this is true. On the face of it, therefore, this could even extend to false or bad faith allegations. Certainly, these types of allegations have not been excluded in the initial drafting. However, the victimisation provisions in Clause 27 of the Equality Act 2010 may be instructive here. Workers are protected from detrimental treatment where they've raised an allegation of discrimination. However, that protection is not engaged where the allegation is false or made in bad faith. It will be interesting to see whether similar drafting makes its way into the final version of the bill. Without this caveat, as a matter of contract law, it appears that employers will be unable to prevent a worker from repeating false or bad faith allegations, even where a claim has been settled. They would still be allegations after all. An individual against whom false or bad faith allegations have been made would have to look to the law of defamation for recourse. What is relevant harassment and discrimination for these purposes? Harassment covers all forms of discriminatory harassment, sexual harassment, and less favourable treatment for not having submitted to sexual harassment. It doesn't cover harassment arising under other legislation, such as the Protection from Harassment Act 1997, nor bullying more generally. Discrimination covers direct and indirect discrimination, discrimination arising from disability, and failure to make reasonable adjustments. Notably, allegations and disclosures about victimisation are not expressly covered, but it may be that the prohibition on gagging allegations and disclosures about the employer's response is intended to cover victimisation. So which agreements are covered? The prohibition will cover relevant NDAs contained both in employment contracts and settlement agreements, but it won't extend to agreements that satisfy such conditions as the Secretary of State may specify in regulations. These are to be known as accepted agreements. We don't yet know what this means, but there has been an indication that it will cover situations where the worker asks for the NDA. So employers will be wary of this change, although they are now in the habit of carving out exceptions to NDAs, for example, in respect of protected disclosures and disclosures to the police or a regulator. This takes things even further. Workers can make relevant allegations or disclosures to anybody without the need to jump over other hurdles. This weakens both straightforward confidentiality clauses and non-disparagement clauses. It does mean in some cases that settlement may be less attractive for an employer. The glimmer of hope is that NDAs may be permitted where the worker requests one. This would be a similar approach to that taken in Ireland, whereby NDAs are permitted where requested by the worker and where they receive written legal advice before entering into the agreement, and that must be provided at the employer's expense. However, if this exception is permitted, expect it to be carefully regulated to avoid the risk of employers pressuring workers into requesting NDAs. Another bit of positive news for employers is that the ban will not be retrospective, meaning that workers will not be able to unpick existing NDA provisions, provided that they are otherwise lawful. This gives rise to concerns about a two-tier system, whereby those who entered into NDAs before a certain date are prevented from speaking about discrimination and harassment, and those who did so after a certain date are not. Could this proposed change to the law force a change in culture, whereby employers do not feel able to enforce any NDAs which apply in those circumstances? Finally, it's worth remembering that the change doesn't affect confidentiality provisions which are aimed at protecting your IP, trade secrets, or other commercially sensitive information. So the government has said that it intends to consult on what should count as an accepted NDA. This is important and should address questions such as, will employers be able to suggest confidentiality or only workers? What procedure will need to be followed? And will legal advice be mandatory on any NDA in this situation? We don't know yet when the consultation will take place or when the ban will come into force. This isn't mentioned in the government's roadmap because that was published before this amendment was tabled. And the equality law measures in the bill go further than prohibiting harassment and banning NDAs, they will require employers to report publicly on certain gender equality related measures, namely gender pay gap and menopause. Currently, employers with 250 or more employees are required to publish gender pay information on an annual basis. However, they need only report their pay gap figures and nothing else. They're not compelled to explain why the figures are what they are, nor how they intend to close their gender pay gap. In fact, they're not required to close it at all. The hope was simply that what gets measured gets managed, and that reporting figures alone would nudge employers to take steps to close their gaps. However, progress in closing gender pay gaps has been and remains slow. As far as menopause is concerned, the law required very little from employers. Employers must provide a safe place of work and minimise risks to health in the workplace. And, in theory, this includes risks relating to menopause. In practice, we suspect that few employers have built this into their health and safety risk assessments. They may also have obligations if the employer with menopause qualifies as disabled, such as the duty to make reasonable adjustments. So the bill provides that regulations may be published requiring employers with 250 or more employees to develop and publish equality action plans on an annual basis. The equality action plans must set out the steps the employer is taking in relation to gender equality, and the bill says this will include addressing its gender pay gap and supporting employees going through the menopause. However, it's feasible that the list of matters to be covered in the Equality Action Plan could be expanded. For example, one amendment that was proposed but has now been rejected was that it be extended to require employers to explain how they're supporting employees with menstrual health problems and disorders. So what is this going to mean? Gender pay gap reporting will become more onerous. Although some employers already publish sophisticated narratives and action plans, many don't. All will need to publish an annual plan setting out what action is being taken to close the gap. If you're in scope for reporting and you do not already publish a narrative and action plan, now is the time to start turning your mind to how you will do this. As far as menopause is concerned, in-scope employers will need to give thought to what they can say in this regard. Some employers are already well advanced in terms of support offered. Others will need to start work on providing appropriate support measures in order to be able to populate the action plan. That said, most employers will already have some things to say here. For example, the provision of flexible working options and relevant benefits such as discounted gym memberships or employee assistance programs. Separately, the government has said it will produce new menopause guidance for employers, and so this may be a helpful resource. We know that the action plans will have to meet the minimum standards in terms of content, form, and manner of publication, and there will be consequences for failure to comply, all of which will need to be dealt with in the regulations. Presumably, the consequences will bite if an employer fails to publish the plan as required, but it's not clear whether they will also apply where an employer publishes a compliant plan but fails to deliver on the promises contained within it, or publishes a compliant plan, delivers on the promises but fails to make any headway in closing their gender pay gap. In other words, is this ultimately just another reporting exercise? Regulations will be needed to bring the equality action plans into force. The government has also pledged to consult the EHRC on the content of those regulations. The government says the regime will be compulsory for in-scope employers in 2027. In other words, the first reports will need to be published that year, which in practice means the hard work needs to start in 2026, if not before. The government also wants to encourage employers to start reporting on a voluntary basis from 2026. And I'm going to hand over to Amanda.
Turning now to the family-friendly provisions in the bill, looking first at flexible working. So currently you'll know that you can refuse a flexible working request where you consider that at least one of 8 grounds specified in the legislation applies. So that includes things like the burden of additional costs, an inability to reorganise work amongst existing staff, or detrimental impact on quality or performance. Importantly, this is a subjective test. In other words, as long as you consider that one of those grounds applies, and that view is based on correct facts, that is a sound basis upon which to reject a request. The bill is going to change things so that a refusal of a request must be based on one of the existing 8 grounds and be objectively reasonable. It's not entirely clear what this means, but we think it's likely to mean that you will need to conduct a fair and balanced assessment of your needs as the business as against the worker's needs before reaching your decision. And further, the bill will require you to explain in writing why you consider it is reasonable to refuse the application on the chosen grounds. Where a refusal is not reasonable, or where you fail to explain your reasoning in writing, the employee will be able to complain to an employment tribunal. There is also one further small change in this area. From the 6th of April 2024, you have been required to consult with employees before refusing a flexible working request, but that form of consultation was left to you to decide. The bill provides that in future, regulations may set out precisely the steps that you will be required to take in order to comply with this consultation requirement. So what will all of this mean for you? Well, we think that this change means you are going to have to go further to be able to justify the ground or grounds for refusal. For example, permitting trial periods before saying no. Ultimately, we think the end result is that more requests are likely to be accepted. Where an employer breaches the rules governing flexible working requests and an employee complains to an employment tribunal, the tribunal will consider whether the refusal is unreasonable, and if they find it to be unreasonable, they can order you to reconsider the request, and they may order up to 8 weeks capped pay in compensation. And perhaps more of a concern is that if a refusal is unreasonable, that could assist the employee in other potentially more valuable claims. For example, if an employer has adopted an unreasonable position, that could be sufficient to amount to a repudiatory breach of contract justifying constructive dismissal, could also potentially assist in a discrimination claim. In due course, you'll need to think about updating your policies and practices to reflect the new rules on refusing requests, and managers will need training to understand the shift in approach and what that will mean in terms of evidence needed to justify a refusal of a request. In terms of timing, the bill will amend the flexible working legislation. No regulations are needed to affect the change, but the government has said it will consult on the detail of the new approach either later this year or early next year, with a view to the change coming into force in 2027, which is actually quite a long lead-in time for what on its face is not the most complex of changes. But regulations would be needed to specify the consultation process to be undertaken before refusing a request. And so that may be the cause of the delay in this change coming into force. Turning to family leave rights, there are 3 proposed areas of change in the bill. Firstly, in respect of unpaid parental leave and paternity leave, these will both become day 1 employment rights. So currently, employees will need 1 year's service in order to take unpaid parental leave, and employees will need 26 weeks service in order to take paternity leave, and the same service requirement applies in respect of eligibility for statutory paternity pay. The bill proposes to remove both service requirements for unpaid parental leave and paternity leave, making them day 1 rights, but no change is made in respect of the service requirement for statutory paternity pay. There's also a small change in respect of how paternity leave is taken. So currently there's a slightly unusual position in that if you take shared parental leave before paternity leave, you lose your right to take paternity leave. The bill is going to abolish that restriction, meaning that the employee may take shared parental leave first if they wish to do so, and they will retain their entitlement to paternity leave and pay. Finally, the bill will introduce a right to take bereavement leave. So currently, employees have a day 1 employment right to take 2 weeks bereavement leave where a child under the age of 18 dies. And those who have 26 weeks service are also entitled to receive statutory parental bereavement pay. Somewhat surprisingly, there's no general statutory right to take bereavement leave outside of this, for example, when a spouse or parent or sibling dies. Of course, many employers do permit compassionate leave in those circumstances, but there is no strict legal requirement to do so. The bill will amend the parental bereavement leave rules and turn parental bereavement leave into bereavement leave, albeit that some special rules will still apply where a child dies. Regulations will be needed to specify the relationships which will entitle an employee to take bereavement leave. However, we expect that it will cover most close relationships such as spouse, civil partner, other life partner, grandchild, parent, sibling, grandparent. Further, the bill was amended on its passage through Parliament to extend this protection to cover pregnancy loss occurring before 24 weeks as well. The bill says that bereavement leave entitlement will be 1 week's unpaid leave, but it will stay at 2 weeks paid leave where a child has died or where a stillbirth occurs after 24 weeks. So what will this mean for you? Well, the removal of the service requirements for unpaid parental leave and paternity leave mean, of course, that there will be a larger cohort of employees who are eligible to take these forms of leave. You will have to manage the higher number of absences than is currently the case. And in due course, you'll need to adjust your policies to reflect the wider scope. As far as bereavement leave is concerned, many employers already offer paid bereavement leave, so it's not such a big change, but the new statutory right will introduce rules around how that leave is managed, and of course it provides a legal framework for those taking the leave, and your managers will need to be trained on that. You will need to revise or introduce a bereavement leave policy in due course, and also think about whether you will enhance the right and offer paid bereavement leave. In terms of timing, this area is a little bit more involved. The government has promised to consult on the detail of bereavement leave. That consultation is due imminently, but the right itself will not come into force until 2027 and new regulations are needed. But in April 2026, so just 6 months away, the 2 day one rights to parental leave and paternity leave will come into force, and also the right to take paternity leave after shared parental leave will be permitted. And finally, it's just worth noting, as we're talking about family leave rights, that the government launched a wholesale review of the parental leave framework covering all existing leave and pay rights. And that review is intended to consider ways to reset the entire framework, which the government has said has grown in piecemeal fashion and left us with an overly complex system. So all current and upcoming parental leave and pay entitlements are up for grabs. That review is due to close at the end of 2026, and that could lead to a complete overhaul of the system. But the good news is that any redrawing of parental rights would likely be pushed back to late 2027 or even 2028. So as far as you are concerned, I would just put that one on the back burner for now. I'm going to hand back over to Esmat.
So I'm going to move on now to talk about 0 and low hours contracts. Before the election, the Labour Party promised to ban exploitative 0 hours contracts. The bill doesn't go quite this far. It introduces 2 key changes which will restrict the use of such contracts and penalise employers who abuse them. The first is that employers will have a duty to offer qualifying workers a guaranteed hours contract that reflects the hours they regularly work over a reference period. So who is a qualifying worker? These are workers engaged on the following contracts or arrangements. A 0 hours contract or arrangement, which is a contract or arrangement under which doing work is conditional on the employer making work available, and there is no certainty that any such work will be made available. A low hours contract is a contract under which the employer is required to make work available to the worker during the reference period for a minimum number of hours that don't exceed a specified number of hours. That's going to be set out in regulations. We don't know what it's going to be just yet, but during parliamentary debates, the figure of 16 hours per week was discussed. We also don't yet know when hours worked will be considered to have been worked regularly and what is the reference period, although 12 weeks has been mooted. The rules governing this new right are quite complex, but in a nutshell, it requires that at the end of every reference period, the employer must make a guaranteed hours offer to any qualifying worker who is in scope. So it's a recurring duty, and the worker does not have to accept the offer. Even if they refuse, however, this doesn't relieve the employer from having to make offers in the future. The offer must meet certain minimum requirements set out in the bill, and which will also be further set out in regulations. So these include that it must set out the proposed working days and hours or specified working pattern, which must reflect the working hours over the reference period. And in most cases, the terms of the offer may not be less favourable to the worker, for example, making an offer on a lower rate of pay. On top of this, employers must also provide specified information to workers about their right to guaranteed hours within 2 weeks of starting employment, and they must ensure that they continue to have access to that information. A worker will be able to complain to the Employment Tribunal where the employer has failed to provide the specified information, failed to make the guaranteed hours offer or made one incorrectly, and or deliberately adjusted a worker's working hours within the reference period to avoid having to make an offer. Second, employers will have a duty to give any worker without a set working pattern reasonable notice of shifts and changes to shifts with a right to compensation where late notice is given. Again, the rules are complex, but in summary, they require employers to give affected workers reasonable notice of a shift that the employer wants or requires the worker to work, specifying the day, time, and hours to be worked, and any change to or cancellation of a shift. Regulations will set out the minimum amount of notice that must be given, and it will not be more than 7 days. Presumably, this will also address how notice will work where there are unexpected turns of events which require rota changes at short notice, for example, unplanned staff absences. Where an employer cancels, moves, or curtails a shift at short notice, it must make a specified payment amount to the worker. We don't know what short notice means or how much the specified payment must be. Any breach of these requirements will also give rise to an employment tribunal claim for which compensation may be awarded. These changes are going to make it considerably more difficult for employers to manage these types of contracts and introduce risks for getting it wrong. First, the requirement to monitor working hours within reference periods, which will be different for different workers on a rolling basis, is going to be administratively cumbersome, particularly where you have multiple 0 hours or low hours workers. And the requirement to make repeated offers of guaranteed hours contracts is also onerous. The drafting of the bill suggests that these must continue to be made even where a worker has made it clear that their preference is to remain on a 0 or low hours contract. So no provision is made for allowing them to opt out of receiving offers. The other concern is that employers could be left overstaffed when customer demand falls. Although the bill does provide an option for employers to use fixed-term contracts instead of being caught by these rules, it's only permitted in limited situations. And third, as far as the giving notice of shifts and changes to or cancellation of shifts is concerned, there will be a risk of tripping up on the notice requirements, especially if the notice is generous, leaving you liable to make a payment to the worker and open to an employment tribunal claim. It could leave you thinking about switching towards the use of agency workers. However, following consultation, the government decided to introduce similar rules for agency workers. So what can you do? For now, a sensible starting point would be to audit your workforce to identify any 0 and low hours workers, and it might be sensible to focus your attention here on those working below 16 hours a week. Where you have 0 or low hours workers regularly working in excess of their contracted hours, you might consider regularising that situation before these rules come in. The government has committed to consult further on these changes in autumn this year, and multiple sets of regulations are needed to bring in these reforms. There will also be detailed guidance. The government has said that the changes will come into force in 2027. Before the election, Labour promised to extend the time limits to bring claims in the Employment Tribunal from 3 to 6 months. There are a few claims which already have a 6-month time limit, but the vast majority of claims have a 3 months time limit. So what is this going to mean? Settlement agreements will often be used where it's thought there's a high risk of claims, and this change won't affect that practice. And actually, the longer the time frame to allow settlements to get over the line, it could mean that the individual will not need then to file a protective claim. So that could be a positive. However, where you don't use a settlement agreement, this change does mean that you can't consider yourself to be out of the woods in terms of litigation for a longer period of time. You'll need to preserve relevant documents for longer, and tribunal hearings could be scheduled quite a long time after a claimant's employment has ended. It may be difficult then if witnesses have moved on to new employment by the time the hearing takes place. The government has said that this change will come into force in October 2026. I'm going to hand back over to Amanda.
Thanks, Esmat. Okay, so we've outlined lots of dates as we've gone through today's webinar. So this slide brings them all together for you in one place so you can see them at a glance. I'm not going to talk through them, so don't worry. As mentioned at the outset, we've covered most of the key aspects of the bill today, but we've not looked at certain sector-specific measures, measures affecting trade unions and industrial action, or the Fair Work Agency. And just for completeness, I should mention that we've also not touched on a few smaller aspects of the bill, namely statutory sick pay, holiday pay records, tipping practices, and regulating umbrella companies. And just before we wrap up, don't forget that the government's appetite for reform does not end with this bill. Amongst other things, there are plans to introduce combined discrimination claims, ethnicity and disability pay gap reporting, equal pay claims on the basis of race and disability, a new statutory code of practice on the right to switch off, a consultation on workplace surveillance technology, introducing a single worker status, and improving TUPE rights and protections, and much more. But we think these things are probably best left for another day. So that brings us to the end of today's webinar, and we do very much hope you found it useful. On the slide, you can see our contact details, so please do feel free to get in touch with us in connection with anything that we have discussed today.